Hi everyone, and welcome to today's session where we're looking at the topic of dealing with trustee changes. We know within the SMSF landscape there are a number of events that might trigger the fact that we need to be making changes to the trustee structure of the fund, and that is maybe at an individual trustee level, but it could also equally apply within the corporate trustee as well. We've seen changes historically where we may have moved from individual trustees to corporate trustees, but these emerging issues now through things like members passing away with our much older clients and also through incapacity or even residency are all really good examples that we need to be on top of what needs to occur from a compliance point of view when it comes to those trustee changes that are occurring. So in today's session, I'm going to take you through some of these technical elements, but then I want to dive into our platform and show you some of these documents that we have now developed to assist you throughout this process. So we'll be looking at the different trustee changes that we're currently seeing, the assessment of what those changes mean, like I was explaining before, dive into the documents that we're using and talk to the additional documents that we're kind of building along the way as well. So let's get stuck into it and talk to the fact that when we see particular changes, we need to ask ourselves, well, what might actually occur within an SMSF that would require or could require a change to the trustee? So as I touched on at the beginning, succession issues are becoming more and more relevant to many of our clients. We know that SMSF corporate trustees are now the dominant trustee structure, but we still see quite a significant number of changes of trustees where we are making that shift from individuals and those individuals then switching over to corporate trustees to naturally address those succession issues where a member dies and we may want to have that sole director looking after the money inside the fund for their own benefit rather than having to appoint a second individual trustee. The other aspect, of course, is the fact that we've seen that increase from 4 to 6 members. So therefore, whether they're individual trustees or they're corporate trustees, there is a requirement to make changes within the trustee structure to ensure that we continue to meet the requirements of being a complying SMSF in accordance with Section 17A. We then look to these other events that occur throughout the lifetime of our funds that we do need to address, and some of these are much more emerging than we've ever seen before. And loss of capacity is certainly one issue where we then need to understand and explore, well, what steps need to occur for that enduring power of attorney to be appointed and come in and step into the shoes of that member who now can no longer act in the capacity as a trustee or director. Death of a member, similarly, we have those carve-outs within Section 17A that allows us to deal with the requirements of a member passing away and then having to resettle that trustee structure within that 6-month period to ensure that we continue to operate as a complying SMSF. And then we have the residency requirement where once we get beyond that temporary absence issue, then we naturally have to contemplate from a central management and control issue, who else do we want to appoint into the fund? So they're just some of the examples that we'll be talking to today and showing some of the documents around. On top of that, we then would need to contemplate things like, well, what are the obligations of our regulators? The fact that we need to report those changes within 28 days of an event occurring within the company with ASIC. We have 28 days around the change of details for the regulator as the ATO, where we're making changes to the trustee or the directors and members and so forth in there. That has a flow-on effect to things like financial institutions and registries that we would need to reflect those specific changes. And there are other things, in particular property, and again, reflecting those changes on the assets of the fund and looking specifically at Section 409 capital A within the regs about making sure we've got the right ownership in place inside the fund there. And as we've already touched on again, things like the definition become absolutely paramount. We need to make sure that we are always following then the governing rules of the fund, and then where relevant, what the Constitution sets out here as well. And in many instances, or in all instances, we need to make sure those two things are aligned based upon what you are trying to achieve with your particular client circumstances. So let's move into this first one, which is around changing to a corporate trustee. Because one of the first things we need to understand is well, who actually has the powers to make and approve such a decision? And quite often when we see deed upgrades and these changes and other related documents coming through, we can see deficiencies in here. And this is where the courts will pull this information apart, because it will require potentially one party, i.e. the trustee or trustees. It may require the members, but there may also be additional parties to that process as well. We may see founders, employer sponsors, participating employers. So understanding in the first instance who has the power to do it is absolutely crucial to that process. And you can see it on the right-hand side there, we have the trustees or members of the fund may by deed. So again, if we go to this next step, understanding not only who, but how this can actually occur. So in the Smarter SMSF documents, we actually get the trustee or directors plus the members to sign the documents. Could be either, but we get it done, I guess, on a perspective that they are wearing dual hats, and therefore they are making those decisions in respect to both being a member of the fund and also as the trustee. But as we go into these steps that we need to understand, what is then important is to say, well, procedurally, what do we need to do and how do we need to get done? So you can see in Rule 2.4 here, they may by deed appoint a new trustee, so long as then, of course, we remain a complying SMSF. So understand within the deed the requirement. Is it done by deed? Is it done by resolution? Or is there some other format? And as we work through that paragraph 2.4 there, what you can see is there are a number of triggers that we need to follow to ensure that we've done this process properly. So we know that the fund must remain a complying SMSF. So we need to adhere to the timeframes to ensure we don't prejudice that definition within Section 17A. It also talks about the fact that it requires consent. So we have to put in place some form of documentation around the person coming in is consenting to that appointment. We also have the fact that the new director or trustee must ensure that they're not disqualified from being able to act as a trustee. So there's a disclosure obligation we have there. And finally, that any appointment that they're actually agreeing to abide by the rules of the fund and the superannuation laws. So again, we've got some type of acknowledgement in that process that we need to look at as well. So they're all the crucial elements that we need to step through in looking at the deed, and therefore making sure our documents are robust enough to comply with what the super laws are doing, but what our governing rules and our constitution, where relevant, would be telling us to do as well. So when we go to then that constitution, again, we need to look at and apply the principles of what that says to ensure that we are doing everything in accordance with the operation of the fund, operation being the constitution in this instance, lining up to and matching, hopefully, the deed. Because in many instances, we do see anomalies between the way in which voting rights are done within an SMSF deed that may be updated regularly. But then what happens is that the constitution that may have been done to set up that fund some time ago hasn't been updated. And then you've got a conflict between how voting might occur within the fund versus how voting might occur within the constitution. The Smarter SMSF deed talks about the fact that we have $1, one vote, I should say, per dollar of account balance. Now, that is relevant inside the Smarter SMSF deed, but it then also applies in respect of voting inside the Constitution. So if we want that approach to be taken, but our Constitution then talks about the fact that a director has one vote each, well, then you're going to come up with an entirely different outcome potentially than you may have wanted, because of the fact that the two documents from a trustee to the fund perspective aren't actually following what you are wanting them to do in the first instance. So when we are making that change to the corporate trustee, we do need to ensure that we're walking ourselves through all of the particular processes that now form part of that appointment of the director. So we know we need to get our director ID obtained at least one day prior to the appointment. We need to get our consent to act as a director, and I'll go through some of the changes we've recently made to that document shortly. We would naturally look at the incorporation of our special purpose trustee company. We need to get our ATO trustee declaration if that hasn't already been done. And then we've got the relevant documentation that again follows to the regulator. Now, we do and have continued to see changes around the way in which these documents can be signed. In that respect, I'm saying above and beyond what would be done in a physical form or wet ink. We have recently seen changes to the Corporations Act that will allow for things such as a consent to act as a director to now be signed in a technology neutral way. So any document that can be signed under the Corporations Act from about the 15th, 14th of September can be signed in a technology neutral way now. So these are all things that we're seeing evolving, as opposed to the consent to act as trustee or the SMSF or the ATO trustee declaration, I should say, under section 104A, that cannot be signed in any other form other than wet ink for it to be valid. So these are all the little nuances that we need to understand as we work through changes that are occurring, not only within the laws, but then what we need to do within the events that are occurring with our SMSF clients. So we do have a change of trustee deed of appointment and retirement document, and I might just jump over to the platform now to actually highlight what we actually can do in this space. So you can see here, I'm on the Smarter SMSF platform. I've just typed in here change, and that brings up a range of documents here for us. So we have our change of trustee form, and what this change of form is doing is it gives us multiple options in respect to events that are occurring within our SMSF. And what I mean by that is that we have changes that may be in relation to individuals moving to companies, which is the most common one. Companies may be going back to individuals, where we may be just adding an individual in. So it might be that fifth or sixth member that I was referring to before. The fact that we might be removing a member. So this is not removing a member in respect of someone passing away or through incapacity. This is just simply someone is leaving the fund. Maybe they're rolling over. It might be through a family law settlement or whatever the case may be. The fact that we may be adding and removing at the same time, and then where we're going from company to company. So we've got all those combinations within this change of trustee form to be able to manage any of those particular situations. And once again, you can see in here, we ask the questions about who actually holds the power or powers to be able to make those decisions. And where we have in the Smarter SMSF, typically we would select the two of those, but you may have additional parties that come into this process as well. And you can see down here, there are a number of additional functions that may exist that you would then look to include in here. So it may be a founder, then it may be an individual, and we would put that individual's details in there so that when the change of trustee is being prepared, that additional party is actually being added into this process as well. Otherwise, it would invalidate that change. And again, this is where we're seeing more and more being referenced through the courts because of the fact that we actually haven't followed what the deed or what the Constitution says in respect to whatever that relevant circumstance was. Okay, so I'm not going to spend a lot of time here today walking through the mechanics of these forms. I'm sure many of you understand, the way in which these work. In a lot of instances, we have tooltips here that actually help you to understand some of these particular issues. And through our knowledge base here, we also have the ability for you to go in and have a look at relevant documents that we have got together in here as well. So we've got a change of trustee form. You can go in and you can have a look at the sample document in there and see what the document brings out and what it generates and so on and so forth. So if I just scroll down a little bit further, you'll see in here in this one, we've got 2 individual trustees converting in this instance to a corporate trustee, and you can see all the relevant information in that particular sample document there. One of the things that we are currently working on is, as part of a workflow, is that you'll be able to, from this change of trustee, if you're wanting to do, say, a deed upgrade, even where you're doing the company, you'd be able to order that company first, and then from a workflow, you'll be able to use that data from your company order to bring it into your change of trustee, and from your change of trustee, you'll then be able to do the next step that might be around maybe a deed upgrade. So workflows is becoming something we're doing a bit of work on at the moment, and really looking forward to rolling more of those out. We've had a lot of great feedback from our fund establishment process that we've built as a workflow. These are a range of items that we can see to help you save time through that particular ordering process. So I'll go back to our slides and jump on to our next part. And this is around the fact that where we actually have a party that is leaving both the fund and or the corporate trustee. So how can a director be removed or retired? And again, this boils down to understanding what does the process actually require us to do? Does it have to be done by deed? Can it be done simply by resolution? Or is there some other thing that says it has to be done for it to be valid? When we have someone that actually leaves, and this may be leaving ordinarily, it may be that they're leaving in the event of death, but one of the things that is very clear within the Smarter SMSF deed is when that person leaves, so i.e. when that person is no longer a member and they were then departing because of that membership, that they can no longer, from a Section 17A requirement, be a director of that corporate trustee. Most likely there's one scenario I can think of, but in essence, they're leaving. So we've got a family law settlement, as I was touching on before. What occurs here is where they are no longer a member of the fund, then, and they are retiring or being removed as a director, their shares at that point in time are ultimately forfeited in the trustee company as well. So little things, understanding what is happening from the corporate trustee really becomes important too, because quite often we see someone go, oh yeah, well, they're removed as a director, it's all done and dusted. Well, what does the Constitution say? What do those rules talk about when that member departs? So do you now need to do a share transfer, or is there a forfeiture of the shares, like with the Smarter SMSF deed, which means you're going to be required to do the relevant reporting from an ASIC point of view because of the forfeiture of those shares. And again, you can work through this process as part of the preparation of the relevant documents. In this instance here, we're looking at the removal of a director. So we're required to deal with the membership. So the membership with that departing member means that we need to cease them as a member, and we have our adding and removing member documentation on the Smarter SMSF platform, and we're rolling benefits over. We've got to deal with SuperStream or maybe a lump sum payment. And again, that's a document that we do have available on our website, and we have our ATO reporting within the 28-day time frame about their removal as director, trustee, and member. But then we have, from a constitution point of view, we've got to deal with the director and the relevant shareholder rules. So cessation as a director, the potential forfeiture of the shares, or whatever your constitution says around that process to ensure that you're meeting those relevant requirements, and then reporting those within, again, the prescribed timeframes that ASIC would enforce. So the other document that we have created recently is in respect to these changes, is around making the changes to directors. And in this instance here, you can see it allows for you to deal with the appointment, the removal, or where we may be adding and removing as well. So here, what we've done is allowing you to go through and document the relevant steps that would need to occur. Some of this, yes, you may be able to do through a CAS 360 potentially, but similarly, we've built a range of additional functions here that link back to what the Constitution specifically says, that is with Smarter SMSF. You can see here some of the decisions that would need to occur. I might just quickly scoot through this just to make sure I'm not missing anything that I wanted to tell you on the next page. And then what we have here is the ability for you to then naturally generate the document. You can see here we've got the one. I'll just say that's John Smith. John, and maybe Jane's the one that's going to be leaving here. So it'll give us the flexibility in here to choose how many are attending the meeting. I didn't choose a meeting date. So here we're not saying how many are directors, we're simply saying how many are attending the meeting that would deal with that, full name of the person that's leaving, the relevant rule of clause, and again, you can see all this information in here. And then you can effectively put in all that relevant final detail, the date in which it's going to take effect, the address of the person that's moving, review that document, and then naturally submit that particular order. So fairly straightforward, both in the context of removals and then the appointment of different parties as well. So both of those functions are captured, well, three combinations: the ability to add, the ability to remove, and the ability to add and remove at the same point in time. So if I go to the completed orders page here, and you can see in here, there's just the ability to review that data. You'll get that sent to you if you're a member. This will be applied against your counter. If you are buying this on a pay-as-you-go basis, then a price will appear there and a credit card for payment as well. So one I've prepared a little bit earlier here for you is in respect to the addition and removal that I was talking about here already. So this is just taking its time to come up. But ultimately, what you can see here is we've got a changes of directors here. I've used the integration in this instance with class to be able to generate this. So I'll come back and show you that in just a second. But you can see here, we now would have our document in this instance to add here. So we've got the appointment of a director only, John and Jane Citizen. We're appointing Tom in this instance. We have all the relevant process in accordance with the Constitution, and we have our procedural things that would need to occur in here. So this is our decision around the appointment. We have our notification. We have our acceptance. So we have here our consent to act. You'll notice here, these are changes that have been made only in the past week or so to our consent. We now have the ability to populate for new company orders, but then also bringing this into these documents, the ability to have that director ID included. And we've got some additional requirements under the Corporations Act that deal with the consenting and the fact that we deal with some technology neutrality requirements here around meetings and holding calls and so forth. We have our consents to act, both from the Corporations Act point of view, but because they're being appointed under Section 118 of the SIS Act as well, we have to have two consents. One is in terms of the consent to act as a director of the company, but then also where they're acting as a director of a trustee company, we also have that requirement under Section 118. And we again have made some changes simultaneously to this document, and we've made very clear, we've brought in some of the additional disclosure obligations to say that they're not disqualified, made them more, I guess, upfront. Previously, we had them at the bottom of the page here that were kind of an asterisk of what disqualified meant. We've now set those out in here more specifically, and then naturally in this instance, Tom would sign that off. And we pre-populate the trustee declaration form as well, just to save in that particular process too. So again, these documents are all here to enable you to go through and do this as quickly and as effectively as you possibly can. So we have built out our integration with the adding and removing, or the changes to directors here. I'm going to use the class one here. You can do this within Simple Fund 360 as well with the form that we have in there. So I just thought I'll utilize this one here. I need to just make sure I've got my multi-factor in front of me here, which I do. You can see here it'll choose the business levels that you've got. So in this instance, I'm going to choose this one here. And then what we're going to be doing off the back of this is you'll be able to then go in and access the changes to directors form that you can see here. Our upcoming Smarter SMSF update next month, we're going to be showcasing the new Smarter SMSF platform. It will be released in beta shortly. So this class, Simple Fund, and also Supermate integration is having a major overhaul from where it is here. So I encourage you to sign up for that to make sure that you have a look and find out more about the enhancements that we're making into our document platform. But you can see here, the idea is that you'll be able to use the integration, choose your fund, and then naturally all of this information is going to then populate into that form to save you that time around the information that we already know from within your SMSF software. So you'll be able to go in, you can see all the detail here, the members, the directors' addresses, so on and so forth. So again, I'm not going to bore you with the time here, but just wanted to show that that integration populates all that information from your SMSF software. So let's go back again to our slides and we will carry on with the next part here. And this is these events that I'm seeing more and more of in the conversations that we're having with our members about what we need to do around changes where someone has lost capacity in particular, and then also in the event of death. So in this instance here, where we're looking specifically at incapacity, you can see on the right-hand side here, we've got our Rule 5.4 that naturally says that under 17A, within the SIS Act, and more importantly, in accordance with the Constitution here, a person may not act as a director where he or she is under a legal disability, and ultimately is to be removed from that position. And then we would need to look at appointing the person's legal personal representative, which in this instance we know under 17A3 requires us to appoint that enduring power of attorney. And we have a 6-month time period to be able to facilitate that. So the change here occurs at a director level, but ultimately the individual remains a member of the fund. Now, we not only need to deal with the issues of the director, we also then need to consider the fact that that individual holds shares. So if the legal representative, as you can see at the bottom in 13.5, is entitled to shares because of the mental incapacity of the shareholder, then in essence, we need to make sure that we're looking at the transfer of those shares across to that party as well. So again, from a procedural point of view, we've got to go and look at the appointment as an EPA, as an alternate director. When the EPA must also meet the requirements of obtaining their director ID within the prescribed timeframes prior to their consent. They would need to get an ATO trustee declaration completed if they haven't already done one. So they might be wearing dual hats. So if they've got that trustee declaration done for another capacity already, i.e. they're already a director, a member of the fund, and maybe they're now doing it for their spouse, you wouldn't naturally need to complete that again. We have our Form 484 requirements around changes to that company. And again, we have our changes of details where we're not removing the member, we're removing them from their capacity as a director. And therefore, we would need to put in place and report to the ATO the changes in respect to the appointed legal personal representative in that instance. So again, we've got a number of documents here that enable you to deal with the appointment of another party in respect to legal disability. And in our deed, we refer to it as the alternate director here, is a person that's been appointed on behalf of a member either through their death or where they are incapacitated, so they're under a legal disability, or for some other reason, and someone holds an enduring power of attorney for them, so therefore they can come in and act on behalf of that particular person. So in that instance, as we jump back to the platform, again, what we have done here is we have created what we call removal of a director, the appointment of an enduring power of attorney. So this was originally created off the back of building this for incapacity, but what we have now done in here is we've expanded this out to allow us to actually not only include, so I'm just going to go ABC, Co-Proprietary Limited. We are now also going to ensure that we can utilize this for any other purpose whereby an enduring power of attorney is being appointed. And what I mean by that is there are multiple ways in which an enduring power of attorney can actually be appointed. And that may be, yes, in the first instance, we've got Jill here that may be looking after her husband, Jack, who has lost capacity. But it could be that in this instance that Jack has gone overseas. So you can see here we've got has lost capacity as an option that would deal with that specific issue. But we've also got the fact that a director is resigning from the role. And again here, the resigning from the role may be for the residency rules, so the absence is no longer temporary. But a common one we're seeing more and more as well now is the fact that the person is much older in life. They still have capacity, but they're worried about the loss of capacity in the future, or they just need that support to come in. So I've seen examples go through over the last few months where we've actually appointed maybe a child in to act as the director, and you've got mum or dad maybe inside the fund. They've still got capacity, but they're actually just relinquishing that role to another person, family member in this instance, because they need the support to be able to do that. Now, you might say, well, why are they running a self-managed fund? There are other reasons why that may be relevant from an asset point of view, from a balance point of view. Ultimately, there's a decision that needed to be made, and therefore they're put in a separate party to actually help deal with that specific process. So we've got those combinations then available within here. And again, we've got the different tool tips in here to help you go through and understand what is being put in place. So you can see in this instance with the director, we can see the information down here. How many attorneys are being appointed? Are they already a director? So in this instance, it might be that we're actually using Jill because Jill is already the appointed. She's a member and a director herself, and she's also the attorney for her husband in this instance. Put the date in, put all the relevant details in, and again, we would walk through that particular process. It could be resigning from the role. Again, it might be a residency issue. Who's the appointed person? You've got that choice of saying, is it someone that's already appointed? If it's not, who is it? Put that detail in, and again, you'll be able to go through and complete that particular ordering process. So what I'll do, naturally, I've gone through and prepared something here to help you understand that process. So this is in beta because we did kind of expand out on those combinations. So this is actively, I guess, open beta for you to be able to use, but we've just taken the opportunity to get the feedback at this point in time before we call it actually technically in live production. But you can see here again, we'll go and grab this document, and you can see in it there as the legal personal representative, they've come in to advise that the relevant party has lost capacity and therefore they hold that enduring power of attorney, and we're walking through, in essence, the process that needs to ensure that the fund continues to comply. So both in the context of the Constitution, we're following what the Constitution tells us, we're looking at the requirements of what the law tells us, and then we're going through that appointment process and resolving to get those things done and dusted, and then naturally that notification would come back. We will look at building maybe some checklists to support this process that talk through the other elements. So some of those things that I spoke about at the beginning of today's session, around the reporting requirements. If you think that would be beneficial, please let us know. But we're at this stage, we're just trying to get people to make sure we've got our I's dotted and our T's crossed in respect to the actual documentation following the Smarter SMSF deed and constitution as well. So let's keep moving on, and then we look at the actual death of the member. So again, we've got here some really important trustee level and member level considerations. So here we've got the death of the director member. So where the company acts as trustee and the member dies, then naturally we have to work through the process of A, paying out the benefit, but B, well, do we actually need to appoint someone or not? Because 17A is a permissive function to allow for someone to step in for the deceased to help pay the superannuation death benefits, but it's not a mandatory function to do so. So you do really, again, need to understand what your deed tells you that needs to occur. Smarter SMSF's deed follows what the regulation says, or what the SIS Act says around 17A, and that is that you don't have to do it, but what we do allow you to do, subject to the consent of that person, is that that person can be appointed, and we incorporate that within the binding death benefit nomination. So when you go to our binding death benefit nomination via our knowledge base here, so I'll just bring this up. If we go to, might go to our deed upgrade document, I'll just go to the back of that form and I can show you in there how that actually works. So this is our most recent update through to July of 2023. So if I bring this up and I take us down to the back of the document here, so we do have in the back of the deed, the samples here are what the fund must comply with. Okay, so Schedule 1 and Schedule 2, because what Hill and Zuda confirmed and what we've known for a long time is the fact that what the rules of the fund say is what we must do and adhere to. So in this instance here, we've got our binding death benefit nomination, or non-binding. I'll go to our binding one here. You can see in here the fact that we have the ability to nominate a replacement trustee. So we don't have to, and therefore that would mean it would rest with the remaining trustees of the fund or directors of the corporate trustee, unless you actually invoked someone to come in at this point in time. So getting all this information is absolutely crucial. And again, I've highlighted today the procedures that we need to be able to work through to ensure that we don't trip up and therefore we don't end up as that next case in whatever court may be around whatever jurisdiction in Australia. So let's keep going backwards and forwards through these, but just again, highlighting that importance of the trustee level issue that I just spoke about there. And then the fact that once the benefit has been paid, we've got our replacement trustee rules to ensure that we remain a complying SMSF. We meet that definition within the 6 months and therefore might need to change to a corporate trustee. We might need to appoint a separate person to a role as trustee of the fund. There's a range of steps or considerations that we would need to explore. We then have, and that's only the trustee level, we then have our member level considerations. And this is the fact that we need to pay the death benefits. We need to look at the instructions, as I was just highlighting within the Smarter SMSF deed there. We need to contemplate whether the pensions are reversionary or non-reversionary, and whether in the instance of it being non-reversionary, is it being paid to a death benefit dependent, and that they might want to start a pension with that superannuation death benefit as a tax dependent beneficiary. Or is it a reversionary pension and therefore that pension automatically continues under the rules of the deed? And therefore, then all of those instances, we at Smarter SMSF have document combinations to be able to suit what would be required in those instances. So again, we've got a sample here, or we've got a change of trustee in respect to not only our change of trustee ordinarily that we were speaking about before, so I might just go back and close some of these, but we also have separately a change of trustee death of a member form. So we wanted to distinguish from this because quite clearly we're not adding the party of the deceased into this, other than the fact that we need to recognise who the member was that died and ultimately that the benefit was paid to them. Okay, so again, we've got a process in here. So we've got our ABC SMSF. We'll just put in the date there. When you put in the fund cert, you'll see here as I'm working through, it's a fully searchable address. I should also say that it is, if I look at my Suite 4, Level 7, 350 Collins Street, it does that depth. Okay, so that's the other thing that's worth noting is you can go right down to suites and level numbers and unit numbers and all that sort of stuff. And if you can't find it, then what you can do is you can go into the manual address input that you can see here as well, and that will then open up the ability for you to put the specifics in there. But I'm going to go back and just put any other address in there. Again, we have our trustee process that we'd need to walk through. A lot of this you'll be able to import naturally as well. How many remaining members, how many directors remain following the member's death? So it may be, in this instance, I'll just choose the one. So we'll say it's Jill Jones here. We've got an address. Is she a member of the fund? We've got our address again here. You can see you can choose from the different ones that may be in here. You might have a registered address that's different to the trustee meeting address, for example. And then we need to, in this instance, now specifically look at things around the deceased member so that we're picking up like date of death, who the individual is, and then we're walking our way through the appointed parties that would occur thereafter. So what type of change are we making? So we're replacing a deceased individual trustee, changing from individuals to corporate, we're changing from corporate to individuals. So you've got all those various combinations there. So in this instance, maybe we're replacing yeah, it doesn't really matter. Or we might be removing a deceased individual only. Okay, so you're then putting in the particulars here of that deceased. We're looking at things like the variations, how many times has it been, and filling out all that relevant stuff. And then it's these things that we spoke about at the very beginning about what are the who have the powers, how are those powers to be applied, and then let's go through and look at who's being appointed. Is a replacement trustee? Who is that person? Get that detail in. What's the relevant rule of clause? Go through and then naturally complete that overall process. And again, we've got a sample document in here around the change of trustee. You'll be able to see what that document then would naturally generate off the back of that process. And you can see some of the references at the top of the screen there around what we're actually adding into that. So again, we've got the specific outcome here, and then it's acknowledging that that individual died, that they're being removed, that we have to comply, and you've got the newly appointed parties as part of that process as well. And again, we'll build some workflows to help support that. We've got the relevant consents and the trustee declarations and the like as well. So very comprehensive in terms of what we have in this suite of change of trustee documents. All right, let's keep moving on, and we're getting close to wrapping up this today for you. So we have a number of documents, I guess, that I've highlighted through today. So that just gives you a bit of a summary on the individual trustee side. So the changes that we spoke through earlier, to appoint, to remove, to appoint and remove, individuals to corporate, corporate to individual, all the combinations are there. We just spoke about our change of trustee, death of a member individually, and we're still working through the incapacity and residency issues where we appoint the EPA there. So if you've got something you might need specifically, we've got our templates there. We're just working through the forms. Similarly, with our corporate trustees, as we've gone through today, we've shown you our changes to director form, the fact that you can add a director, the fact that you can remove and you can add and remove, and you've got those alternate options. We've got the ability to remove in the event of incapacity. We've actually got it in residency now as well. I should have changed that there because it actually covers under EPA. The only one we've really got left now is just dealing with the issues around the death of the member. Again, we've got much of the templates resolved. It's just packing all that together, which most likely we're going to be rolling these straight into our new document platform that we'll be looking to launch out over the next month or so. So that's pretty much it. So some key takeaways for you today. So hopefully today I've been able to highlight to you that getting it right around these changes to trustees and corporate trustees and stuff is crucial. So it is all about understanding how it can be done. So what are the steps involved and really the order of what needs to occur as well. We are seeing more and more and more of our SMSF clients requiring changes, whether that is just generally occurring because of events throughout their lifetime, but more importantly, we're seeing many at the later stages of these SMSFs due to incapacity, death, and other life events. And ultimately, we're here with our knowledge and level of specialization to be able to support you with these sort of documents. Okay, so we're continuing to build what we believe to be the most comprehensive suite of documents, not only in this space, but across our 80+ documents that we have on our platform. And they're all designed to help you understand what needs to be done and support you through the changes that you'll see with your clients. You don't necessarily see these things each and every day. So these might come about once every few months, once every year, once every few years. This is where you can come back and tap into the expertise that we have at Smarter SMSF to make sure you're doing the things right for your SMSF clients. So that's it. Thank you for joining me today. As we always say, be smarter than your average. We have a number of events coming up. You can see those on our events pages. Most importantly, that Smarter SMSF update, we will be going through a whole raft of changes that we've been making across Smarter SMSF over the last quarter. Like I said, it will include a bit of a sneak peek on our new document platform. We also have our next SMSF masterclass, which we'll be releasing next month for registration. It is included for our members as part of your CPD subscriptions. So make sure you sign up for that when we get that information through. Otherwise, hope to maybe see you at one of the upcoming SMSF Advisor Technical Strategy Days around Australia, where I'll be both speaking and MC. But as I said, you can go online, and our smartersmsf.com/events page gives you everything you need to know about what is coming up. And also importantly, not only this session, but a range of these sort of sessions that we run, we now add to our YouTube channel, and includes not only these sort of webinars, but also our Feeling Smarter weekly series that Tim Miller and myself talk about a specific topic that we are looking at and dealing with at this point in time, whether it's a member question that comes through, it may be just something that's being released, 5-minute grab of a particular topic. So I encourage you to subscribe to our YouTube channel and find out more about what we're doing at Smarter SMSF to be able to support you in your business. That's it from me. Thank you for joining me today. If you've got any questions, please feel free to ask them now. Otherwise, you can get in contact with us. You can see that detail on the screen. Have a great rest of the day. Take care and bye for now.